tonight. Tonight is a very important part of a process that has been launched in Whittier. Whittier has a long history of presence in the greater Los Angeles County area. As Angie mentioned, I had the honor and privilege of serving in the legislature for 16 years, my last 4 as the Senate Majority Leader. And I got into the public policy arena because I believed that government could do one of 2 things. It could support and help people and communities, or it could do the opposite. And from a framework of mine, just to put us into my generation way of looking at things like government, I grew up in the 60s, 70s, gives you an idea of how old I am. And it was a time when that generation, my generation, questioned government. We probed government. We didn't trust government. We challenged government. And it was at a time when civil unrest, the civil rights movement, the farm worker movement, and other civil rights actions occurring in that period of time. And probably the most significant piece of legislation that came out of the civil rights movement, very defining for us as people, for us as society, was the Federal Voting Rights Act. It was a piece of legislation that allowed for the discontinuing, I should say, of disenfranchisement of predominantly African American communities. And so I stand today and say that we stand on the shoulders of those civil rights leaders, of those religious leaders, of those labor leaders who took on the fight from all walks of life, from all racial backgrounds, took on the fight to have equal opportunity and equal justice. And the Civil Rights Act, which is probably the most significant piece of legislation, I would argue and say that Lyndon Johnson signed into law. And so what you have was the beginning and the basis from which communities of color, or protected class communities, I should say, are protected under the Constitution of the United States of America. And as we fast forward, I began to see the whittling away and the challenging of that Voting Rights Act. And lo and behold, this year, guess what? It happened. Sections of that Voting Rights Act that were very significant to states that had to have pre-clearance because they had a history, documented, empirical data of discrimination. And before those states could do anything that would affect the voting right, they had to get pre-clearance to the federal government. Well, we didn't have to go down to the South to experience that. Here in our own county of Los Angeles, the Garza Act was a piece of legislation that really addressed the inequities that were in existence as it relates to the Latino voting population. And so I introduced, in my last years of the legislature, a piece of legislation that I believe is a hallmark of what had been done, but applicable to California as it relates to at-large elections. One only needs to look at your community, Whittier, and one only needs to research, and you will see but one council member has served from our community who happen to be Latino. And so what you have today is a piece of legislation that basically looks at large elections and says if there is polarization of the vote, then there is a process by which you as citizens can petition the court, petition that local government first, to move away from at-large elections, because the net result is prohibiting people of protected class of getting elected to serve. And so you have in this piece and this body of legislation that is now beginning to really take hold up and down the state of California. And I remember the very, very first time I became familiar with this particular issue, the Watsonville decision, small rural communities. And it was a decision that was challenged and taken up to the highest court of the land. And it was a decision that was held constitutional, but very costly, very expensive to launch this kind of a lawsuit. And so in the bill that I carried, I allowed for attorneys to step up, consultants to look at the polarization voting that would be documented, and then give the local municipality, be it a school board, a city council, and other water districts, a subdivision that participates in elections at large, give them the opportunity to say, here's the evidence, here's the empirical, historical data that shows racial polarization of voting, and you get to change that. However, if you don't, then we will take you to court. And however, if you don't, we will allow for attorney fees for those individuals, voters of this protected class, to step up and do what is right. It is time for this community to get away from the at-large elections. It is a process that disenfranchises, dilutes, is counterproductive to the meaning of true democracy, counterproductive to the truth of representation that would reflect and does reflect. And in closing, let me say my intention with introducing and making this bill what it is today was based on the fact that I believe, and so did the legislature, and so did the governor who signed the bill, and so has the courts who have looked at this issue time and time again now on the constitutionality questions, and have found that at-large elections are diluting Latino voter participation that creates a net result of lack of representation in the policy body of local government. And to me, the experience that each of you has is important to that public policy discussion and debate. And lastly, let me say that the remedies that are in place allow for a judge to have discretion. And I would close by saying, when you look at the history and the voting participation propensity in Whittier, you see more votes being cast from Latinos in the general elections versus the municipal elections. And I would say that my intention was to give the courts all the leeway and all the remedies that can and should include the scheduling of these elections so that it does not limit but maximizes what this country is based on, which is true democracy, true participation in a process that is transparent, in a process that allows for your vote to matter and your vote to count. Thank you very much for the opportunity.
So my research, based on the best practices, based on the findings of other political scientists, what should a city council look like? How should you elect it? What should be some of the things to think about? Districts need to be separately elected. Districts with a separately elected weak mayor. That's what I suggest. I think you should have an odd number of councilors. It's sort of weird to propose 4, but the more the better. I think the smaller the district, obviously the more likely Latinos are going to be successful to win, or any interest group, not just Latinos, but any neighborhood interest is more likely to gain representation in the smaller the precinct or the district. I would suggest 5, but actually preferably 7 to 9 counselors, I think would be a perfect council. No gerrymandering. If you've ever taken a class with me, you know every class I teach is about gerrymandering, essentially. It's an abusive process. It's a very problematic thing. One of the problems that whenever I suggest districts, people say, but what about gerrymandering? And I say, I don't like gerrymandering. So you have to draw the lines carefully. I would suggest redrawing them, having language that says they're redrawn every census just to keep up with population shifts, and have a citizen-led, nonpartisan, not appointed by the current incumbent commission. Maybe political science professors or somebody like that, not me, but somebody that could draw districts, lawyers, yeah, but not the incumbents, and not people they appoint, right? And specifically, the language should actually be in there that specifically bars the most common gerrymandering tactics, things like locating districts, looking where incumbents live before you draw the district lines, or packing folks into districts, or cracking folks across districts. Term limits. I think 4-year terms is about the right length of time. You don't want to have them too short because then folks can't get any experience and don't have any ability to get things done. But one of the issues with district incumbents can actually be harder to defeat than at-large incumbents sometimes. They become very popular in their districts. There's nothing wrong with that. It's just one of those things that I think, personally, and I think the literature supports this, and I do have to publish papers on term limits, but that term limits, I don't like all the things term limits do, especially at the state level where they've made the lobbyists and the staff much more powerful. But at the city level, it gets new blood in. I think every 12 years is a reasonable amount of time to have new blood, lets new coalitions come through and elect representation. So term limits is important. Concurrent elections, I think, is crucial to get the increased turnout that people want. My other piece that I published on district elections, my dissertation research was on San Francisco switch from at-large to district elections. And one of the main findings I found, that's weird, one of the main things I found was that districts increase minority participation. That voters are not stupid. They know that under the current system they have no chance of electing anybody, so they don't show up. And they learn that under districts they have better chances to show up, to win, and they show up. And it's really interesting. Like overall, the citywide minority participation didn't really increase that much in San Francisco. But if you look at the districts where minorities had real chances to win, participation was through the roof. And in those districts where they didn't have a chance to win, it was down a little bit. So citywide, it sort of looked normal. When you dig into it and you see like those districts that were black turnout soared. Those districts that were heavily Latinos turnout soared. Those districts that were heavily Asian, Pacific Islander, their turnout soared. So people are smart, people are sophisticated. They know that they have a better chance under the district system, and they will turn out at a higher rate. That's not enough to have them non-concurrent because of the costs of these off-cycle elections is just ridiculous. Not the cost of them, the cost to the voter, right? In time, effort, and getting information. So absolutely need to have them concurrent. I put down fundraising limits. I think that's another thing that's important, but I don't have much research personally about that, but I do think that that's an important thing to try to keep the money out of the system. Last piece I'll leave you with, I think the minorities have a lot to expect from a change to districts. I think they will, there's a book by Browning, Marshall, and Tabb called Racial Politics in U.S. Cities. And they found that their answer to this question is it worth it for minorities to fight for this representation? And the answer is a resounding yes, right? You're going to get better responsiveness to your issues. This is what the research shows. Better responsiveness to your issues, more resources into those communities, better representation on boards and in hiring. Right? One of the things they found was that once minorities were incorporated into leadership positions in city councils, those city councils' hiring practices started to reflect the city's makeup. So if you're 12% black, the city's 12% of their new hires were black. 12% of their police force becomes black. 12% of their fire department becomes black. 12% of their sanitation workers become black. And it's not a quota thing. It's just one of those things where the representation brings about real benefits for their constituents. You're going to see more women on the councils, I believe. You're also, the last piece I'll leave you with, and this Browning Marshall and Tab found this in theirs, based on the Berkeley City Council. After an initial nasty fight, after you win your first seat and get a Latino on the city council, it's likely the fight will be over. That, at least that's the way it looked in when Browning Marshall and Tab looked at this issue. Basically, they fight like hell. They, meaning the majority that currently runs the council, will fight like hell to protect their power. But once they see that the world doesn't crumble when one or two seats become diversified, they start to see that there's other fights that are much more important, right?
I do want to start off by, I was kind of sparked to start off this way by something that Professor Lindgren said, and that was the term limit piece, and I'm not here to really talk about any of that, but it does make you wonder, and so I'll start with this. In 1976, gas was 53 cents a gallon. A peanut farmer from Georgia got elected president. I was graduating from high school, 1976, and Bob Henderson got elected to the city council here in Whittier. And he has been reelected and reelected and reelected, and certainly that has been the choice of Whittier. What a great start. So let me talk about the litigation just a bit. In all of these types of litigation, and it has increased over the last decade since the passage of the legislation, every city, almost without fail, though there are a couple of notable exceptions, proceeds the same way. There is a letter that is delivered to the governmental entity, could be a school district, could be typically a city, but also school district, health districts, advising them that they're in violation of the California Voting Rights Act. They advise them why they're in violation of the Voting Rights Act. And 95% of the time the response is, we will fight to the last penny, and we're not in violation. The mayor of Escondido, for example, to use them as an example, a case I worked on, proclaimed when they got the letter that they were going to use every dollar that they had in the city to fight that lawsuit. A year later, they settled. And it always works that way. They either end up settling. Now, Palmdale was a recent example where they did not settle, and they went to trial and they lost. The cost of taking it to trial, the cost of resisting, in the 16 plus cases that have gone forward, no defendant, no governmental entity has ever won. But the cost of that in Palmdale is going to be north of $1 million just for the plaintiff's lawyers. The defense lawyers will also have a cost, at least 3/4 of that, if not the same. That's almost $2 million for Palmdale. Palmdale has police officers there, they have firefighters, they have government services, they have a lot of responsibilities. In the city of Modesto, the first major case, which was tested at not only the California Supreme Court level, but also the U.S. Supreme Court level. City of Modesto was on the hook for their own lawyers of $1.7 million, and for their plaintiffs' lawyers received an award of $3 million, for a total of $4.7 million. Now, when you present this information to the governmental entity, as I've done on now 2 occasions, you have, again, kind of the same response. And you wonder, at least at the beginning I wondered, what is the motivation for resisting something that is so obvious? You know, Latinos make up 66% of the population here in Whittier. The voting age population, there's a little over 50% Latinos. But yet, in 115 years, only one Latino has been elected to the city council. So you wonder, why is that? How is that possible? Why does that occur? And then when you present that evidence to the city council, and you say, look, here's the problem. You have an election system that dilutes, in fact, the power of a representative group to get anyone elected ever. And then the timing of your elections, the election timing also operates to disenfranchise not only Latinos, but other groups as well, and the rest of the citizens. Let me give you an example of that. In 2012, you had a city council election in April, a very unusual time to have a city council election. And so your turnout in April, your municipal elections, is always extremely low as compared to any other election that is held in the city of Whittier. In June, the turnout is much higher, and in November, the general election, it's extraordinarily higher. 2012, 973 Latinos showed up to vote at your municipal election. In November of that same year, a few months later, well over 14,000 Latinos showed up to vote at that election. That is an incredible difference and distinction in turnout. Now, it wasn't just Latinos, but Latinos made up in November about 55% of that turnout. The rest was everybody else from all other walks of life and nationalities and ethnicities. So the turnout in April for all groups, but particularly Latinos, is much lower in April and much higher in a November election, what is sometimes referred to as a concurrent election. That has operated to disenfranchise a number of groups and has other problems as well, and creates other problems, which will be borne out in our litigation, but has been borne out in other pieces of litigation as well throughout the state of California. And that is that folks tend to stop participating in those local elections that are set at unusual times. They also grow more cynical, and this is proven through studies. They grow more cynical about their government, and a smaller and smaller group of people tend to make all of the decisions for a given community, which again increases cynicism. The single greatest way to change turnout is to change the municipal elections from these unusual times, say in April, to a November election. Now that is not an unusual thing to do, either through cities themselves or the courts. The cities have done that rather routinely over the last several decades, particularly since this legislation was passed. Cities voluntarily do it, again routinely, but not just cities, but school districts. I'm from the city of Riverside. Riverside Unified School District was at large. At some encouragement, they've changed to district-based elections. And they do it voluntarily. Cities can do it. The city of Whittier could do it easily if they chose, and they've decided not to do it. It is one of the things we're asking for in our litigation, but also in Palmdale. Palmdale currently, the plaintiff's lawyer in Palmdale is seeking to invalidate their coming municipal election, which is held in November. November of this year, again an odd year, again an oddly timed year, and they're seeking to stop the election or invalidate the results. One other thing it does that cities like Whittier have had economic difficulties these past few years would appreciate is that when you have an oddly timed election, you spend a lot more money having an election when no one else is having an election, as opposed to kind of jumping on the bandwagon of the County of Los Angeles when they're having their elections in June or November. You save money in June or November if you add on your election at the same time, as opposed to a standalone election that you pay for. The money that you save in those elections, and it's almost twice as much, the money that you save in those elections can be used for a lot of other purposes. This is not a challenging situation, and in the litigation here in Whittier, in one sense, and that the outcome is going to come out as it's come out in other circumstances throughout the state of California. The only question is when. It's not a question of if, but oddly enough, it always comes out it always goes through the same progression. We've made attempts to discuss that with other counsel and have met with resistance, of course, but we were prepared for that when we came in. One last thing is cities are typically, and governmental entities are typically given a reasonable amount of time to respond. Reasonable amount of time to respond to what's called a demand letter or a request letter is about 30 to 60 days. In this instance in Whittier, it was 2.5 years. In June of 2011, the city received a letter from another law firm other than ours. In fact, one of our plaintiffs, Miguel Garcia, who's present today, was a member of that lawsuit, or was going to be a plaintiff in that lawsuit. And so the city has known about that for some time. We followed up with our own letter this year in July. So there's been a great deal of information that they've received in the interim and both before that. Unlike the federal litigation and legislation that has been discussed tonight, California litigation is much simpler and much more streamlined. And we look at a variety of things, but racial polarization is clearly in existence here in the city of Whittier as it is in the other jurisdictions that have been sued under the California Voting Rights Act. It's easy to find, as Professor Lindgren, through his expertise and skills, can attest, as well as the other experts that we have in this particular case. It's relatively simple. With that, I think probably open it up for questions. And I'll finish with this. One thing that we talked about at the very beginning of this lawsuit was, this really is not about Latinos. This is about American citizens having the right to vote.
Right.
All American citizens, not just some. And the diminishment of any American citizen's right to vote is the diminishment of all of our rights to vote. So, and that's really what